କରନ୍ତୁ।
Very good morning to all of you. On behalf of the PG Department of Law, Berhampur University, and the Pro Bono Club of the PG Department of Law, Berhampur University, I welcome you all to this national workshop on alternative dispute resolution. Alternative dispute resolution is a platform of non-adversary mode of settlement of disputes between the parties. Through arbitration, conciliation, Professor Susara, Chairman PG Council, Berhampur University. Dr. Ms. Sri Sachidanand Naik, Registrar, Berhampur University. And two of our eminent resource persons, Professor N. Venkataswarlu, Head and Principal, Osmania, Department of Law, Osmania University, and Ms. Krishna Arjun Badate, Assistant Professor, Marathwada Mitra Mandal, Shankar Rao Shavan, Law College, Pune. I welcome all the participants from the various different corners of our country, academicians, research scholars, professors, principals, heads of the Department of Law of different colleges throughout the country. I hope this session will be of very good session. Now I request our coordinator, Mr. Chitranjan Gogoi, Assistant Professor, PG Department of Law, Berhampur University, to give a brief account of the workshop, Berhampur University, and introduce our resource persons. It's over to you now, sir.
Thank you, Lupto sir. Good morning to one and all present over this virtual platform. I, on behalf of the Department of Law, Berhampur University and Berhampur University, welcome all of you. Esteemed Chairman PG Council, Professor Sushant Kumar Boral, and the in-charge Vice Chancellor of Berhampur University, Professor Gitanjali Das, Honorable Vice Chancellor in absentia, Professor Venkataswarlu N, Madam Krishna Arjun Badade, dear participants, we have organized this workshop on alternative dispute resolution because this alternative dispute resolution mechanism has emerged as one of the emerging dispute resolution mechanisms in the recent years, and due to its advantages as compared to the normal court process, the ADR mechanism has actually gained momentum, especially in the era of commercialization and globalization. It is due to the commercial and globalization, more and more commercial activities are happening, export and import is happening, and due to that, international commercial arbitration and other issues are also cropping up. And this workshop will definitely familiarize you with the theoretical framework as well as the contemporary issues related to ADR. Regarding the university and our department, I would like to say a few words. Berhampur University is a state public funded university. It was established in the year 1967
Sir.
by an act established by the state legislature of Odisha, and it is one of the oldest universities in the state of Odisha, imparting education in both PG, UG, doctoral and postdoctoral courses in science, humanities, business studies, and law. The Department of Law was established in the year 1985. We offer 2-year full-time LLM course, PhD course, as well as LLD courses in our department. The department has successfully conducted different certificate and diploma courses, UGC sponsored course on human rights and duties education, UGC sponsored PG diploma human rights and duties education course. We have successfully conducted PG diploma in disaster management course as well as Club under the financial assistance of Department of Justice, Ministry of Law and Justice, Government of India, and we are striving our level best to impart quality legal education. Regarding our esteemed Vice Chancellor, I would like to say a few words. Honorable Vice Chancellor Professor Gitanjali Das is the first women Vice Chancellor of Berhampur University. She is an able administrator, academician of repute. She has served across the state in different colleges and universities in different capacities like Chairman PG Council, Head of the Department, Dean Faculty of Humanities and Social Sciences before adorning the position of the Honorable Vice Chancellor in our university. She has been a constant source of inspiration for all of us, and under her able guidance, Berhampur University is marching ahead as an institute of eminence. Our esteemed registrar, Sachidandan Nayak, belongs to the Odisha Administrative Service. He has served in different capacities across the state and has shown exemplary performance in his whole career. Our esteemed Chairman PG Council, Professor Sushant Kumar Boral, who is now, for today, he is acting as the Vice Chancellor in charge. He is an academician of repute, having more than 32 years of experience. He is an expert in the field of finance and general management. Besides holding the position of professor and head of the Department of Business Management, he held different administrative positions like Dean, Management and Business Studies, Warden PG Hostels. I would like to thank Sir for gracious presence in this occasion, Sir. Now I'd like to introduce introduce before our participants our esteemed resource persons, Professor Venkateswarlu N, who is currently serving as the head and principal Department of Law, Osmania University. He is an extraordinary teacher having specialization in corporate and securities laws, ADR, ODR, IT laws, IPR and human rights. He was the former director, legal cell and RTI cell in charge. He was joint director, estate cell in Osmania University. He has served as legal advisor and RTI in charge of MG University Nalgonda. He served as a head and principal Department of Law, University College of Law, Osmania University. Sir is an UGC Research Awardee on online dispute resolution. He acted as former additional controller of examination of Osmania University. Sir has published more than 56 papers in various journals on topics related to law and society, law and governance, law and technology, law and corporate governance, law and arbitration. Sir has published different edited books on human rights, corporate social responsibility, IT law. Sir has conducted 3 national seminars in Department of Law, Osmania University, Hyderabad, which are sanctioned by the NSRC. And he has conducted a 10-day national level research methodology training course at Department of Law, Osmania University, which was sanctioned by the ICSSR New Delhi. Sir has attended numerous conferences across the world. He has presented papers in Jordan and Nepal, and he has more than 24 years of experience in the field of academics. He has guided more than 400 LLM students, produced 19 PhD scholars, and 6 PhD scholars are now conducting research under his able guidance. We have with us another resource person, Madam Krishna Arjun Badade. Madam is currently working as assistant professor of law in Marathwada Mitra Mandal Sankarrao Chavan Law College, Pune. She is additionally discharging her responsibility as a coordinator IPR cell and coordinator IQSC cell. Madam has actually done her post-graduation and graduation from Savitribai Phule Pune University. She is currently pursuing her PhD in law from Gondwana University, Maharashtra. She is also a member of IUCN Commission of World Environmental Law and WIPO ADR Young Forum. Madam has presented numerous papers in various national and international conferences. She has published many articles, book chapters. She has also edited one book on transforming dimensions of IPR, problems and prospects of information age. She has delivered numerous talks in numerous workshop conferences. I welcome you, madam, to this virtual workshop. I now would like to hand over the microphone to next for the next agenda to Luktaratna sir.
Now I request Professor Sushant Kumar Baral to kindly address our participants.
Good morning to all of you.
Yes, sir. Audible.
Yes, sir. It is audible. It is audible, sir. It is audible.
Yeah, I'm sorry for the technical glitch. I respected department and Honorable Vice Chancellor in absence here, Professor Venkat Surlu and Head and Principal Department of Law, Osmania University, Madam Krishna Arjun Vadade, Assistant Professor MM Shankarrao Chavan Law College, Pune, and my dear participants. This is one of the proud moments for us that we are going to discuss in this workshop on alternative dispute resolution organized by PG Department of Law, Berhampur University in association with Pro Bono Club, PG Department of Law, Berhampur University. And the title is Alternative Dispute Resolution, and this is an emerging area and most burning topic of this year, of this age, decade. Say, as for the Constitution, judiciary is the first pillar of the Constitution. Second is the legislatures. Third is the executives. Now the media claims to be as the fourth pillar. And say justice, truth. If you see the logo, Satyameva Jayate, truth prevails. Justice for all, equal opportunity, equality, honesty, integrity, and others are the most important words for smooth functioning of any system or a country or institution, and for the development and progress of the nation. But unfortunately, as per the latest news, NDTV news says that there are 69,000 cases in Supreme Court and 5 crore pending cases in different courts in India. 5 crore in the population of 140 crore, and is a huge number, massive number. And in fact, there is a saying, justice delayed is, and if justice is denied, there is huge harassment, huge agony and others, that people don't get justice. Even there are newspapers that many innocent people are in jail suffering, waiting for justice because they don't have any legal support, and or they don't have the access to court, and the pending cases are going up and up. So this is a matter of serious concern which affects the development process of the country. And there is a research finding says stronger the regulation, better the governance, better the development, higher the progress, more equitable growth, sustainable development. But unfortunately, we have Indian system has not delivered it properly. And say in 19 after the framing of constitution in 1951, and after there are 50, 70 years have passed away, but we are our performance is not good, is not good. As a result, we are India being one of the few richest country in the world is backward. And okay, in GDP, total GDP, we are higher. We are one of the fifth biggest economy, but there is lot of many drawbacks. Rich poor gaps are widening. People are richer are getting richer, poorer are getting poorer, and because there is no such legal justice, justice is not delivered properly or timely, and this is one of the major factors of our drawback, or a very minimal marginal progress. While, but this disparity has led to lot of losses, and India is declared as far as the Transparency International. India is one of the most corrupt country in the world. It was earlier a few years back it was 140, and now it has come down to 100 above. So if the corruption is so prevalent and legal, that means that legal system is to be strengthened. The disputes have to be resolved so that people can concentrate. The citizens of India could concentrate on their duty and properly. If they are not deprived of their justice, or there is delay in getting justice, then naturally these people will be frustrated and demotivated to perform better and more. And there are many cases. Time is limited, and I should not elaborate much. Rather, the disputes are rising, and another factor is after globalization, where we are going for in the globalization, we are going for materialistic development, and the value system has come down, and more crimes and more cases, disputes are going up and down. Family disputes are going up and up. Husband and wife disputes are going up and up. Depending on the legal system, then if there are 5 pending cases in different courts in India getting justice, and they are overloaded, and even the recruitment of judiciary all judges are not enough to dispute the end. And again, it is still like there are some systemic lapses, or the system to be changed or reformed, and at par with different developed countries. So, but nowadays, thus with this background, alternative dispute resolution is a very viable solution. Even at earlier in old days, there are Gram Panchayat level, Gram Sabha, Lok Sabha, Gram Sabha, and at Panchayat level there was resolutions are made. At village level, amicable solutions are made, and but now it has not been. It has disappeared because of some other reasons. But if the disputes could be resolved at village level, at police station level, and should not be encouraged to go to court. So then the harassment or frustration in getting justice in present legal system may be resolved, and people can concentrate on their duties properly, which will lead to more employment, more productivity, equitable growth. These four gaps should be reduced. People should get food, shelter, education, cloth and basic necessity, as well as this structure, and the gaps to be reduced between rich and poor. So with these three words, and there are other emerging areas, but now let us be, today's topic is alternative dispute resolutions. So dispute resolution should be done as far as possible and at the earliest possible, so that people can live peacefully, and peace leads to prosperity and success, happiness, and we can be a richest country in terms of resources. We can march ahead and ahead, can be number one. All the best. Thank you, the head, law departmental officer, Dr. Gogoi, and thanks to the audience, participants, and the research persons. I'm thankful to the research persons for their valuable time to interact, discuss, the guide the participant students of our university. Thank you so much, sir, and Madam Krishna, Madam, and all the participants. Thank you.
Thank you,
Dr. Okay, coordinator, sir. Please coordinate. Thank you. Thank you so much.
Thank you so much for those inspiring words and valuable perspectives on the subject. Now, our registrar sir is busy with an important work, so he is not able to join this workshop, this inaugural session. So I request now to our, by the permission of our resource persons, can we start the session? Professor N. Venkateswarulu sir,
Okay.
can we start the session?
Have you completed your session? Have you completed, sir? Have you completed your session? Hello? Hello?
Yes, sir. Inaugural is almost over, sir. Actually, Honorable Vice Chancellor, Madam, she is on leave. So, Honorable Registrar, sir, is also busy in a meeting. So, Chairman, sir, has already addressed. So, we can directly go to the technical sessions, or we can take a break also. It's based upon your convenience, sir.
Okay. After 10 minutes, because most of the Hyderabad participants wants to join, 11:30
Okay,
actually. After 10 minutes, I will commence.
Yes. That will be great, sir. Thank you, sir.
After break.
Am I audible? Hello? Hello?
Yes, sir.
Yes,
Yeah,
yes.
yeah. Sir, I am ready.
Yes, yes. Our resource person, Venkata Sarlu sir, is ready with his presentation. Dear participants, please enjoy his presentation. And we are having actually 30 minutes doubt clearing sessions. After the presentation is over, we can start that also. Session also.
Okay.
So enjoy sir's presentation. Over to you, sir.
Okay. Thank you.
Thank you, sir. I am audible. Hello?
Sir, you can start, sir.
Okay.
Yes, sir. Your voice is
Yes,
audible.
sir. Yes, sir.
I am audible.
Yes, sir. Perfectly.
Okay, right, sir. Right. Very good morning to one and all. I am Professor Venkateshwarlu, head of the Department of Law, Usmania University. First of all, I want to congratulate PG Department of Law, Berhampur University, to conduct wonderful workshop, very relevant workshop in the present scenario, that is on alternative disputes resolution. It is very much important in the present scenario. For that, I am congratulating once again. And first of all, by choosing this workshop by Google Meet, so many participants are joined from different parts of the country. I am welcoming to this Google Meet program to attend the workshop. For this, first of all, I want to say thanks to Lupta Ratna Petro and Rajana Gagoi and Susan Kumar Bansar and other important people who are involved in the workshop program. First of all, what is ADR? Why ADR is required in the present scenario? Actually, alternative disputes resolution concept is one of the oldest concepts in India. Since Vedas, after English period, then after our independence, in the present scenario is also, it is very much important. See, going to the Vedas, whenever disputes comes, people used to go to elders who are well-versed in the particular field, then automatically they will solve the problem amicably and parties will feel happy. Then society feels, when there is no disputes, society feels very happy and everybody thinks towards productivity of the society. That is happening since Vedas. Later on, when you come to the English period, so many legislations are came for settlement of disputes outside the court, and coming to the one of the oldest concepts, panchayats, and community elders, family elders, and members who are in the expert field, they used to settle the matters without knowing we are settling the matters. Suppose if any dispute happens in the office, automatically principal of the college or the head of the department of the college or officer of the college, they'll ask the parties to sit together and settle the matter amicably. This is happening without knowing to the arbitrators also, even mediators also. That is happening since several years. Coming to the arbitration. Arbitration is a method of settlement of disputes, is an alternative to the normal judicial method. It is one of the methods of alternative disputes resolution. Of all the forms of ADR like conciliation, mediation, negotiation, arbitration has become dominant form of ADR. See, these are kind of things came after independence. Before independence also, we were followed this kind of practices without knowing to the arbitrators, mediators, negotiation, different names. And only one important concept has become more popular, that is arbitration. methods are only we are using for some other purposes. Very less people are undergoing this kind of mechanisms. ADR is an umbrella term. Under this, all these kind of things are happening. ADR, arbitration, mediation, negotiation, conciliation, and other kind of methods, lok adalat and other things are happening. Coming to the ADR, why ADR has become more popular? See, in India, since 1947, before the 47, we were using this kind of methods under British rule, and we had so many legislations. One of the famous legislation related to arbitration is Bengal Regulation Act 1772, and consequently so many legislations they brought. Traditional system of dispute resolution methods in India gradually declined because when you encourage these kind of mechanisms, technical kinds of mechanisms, automatically people, intelligent people will think towards the betterment way. That is the reason these things are happened. Without these kind of methods, if you undergo any kind of settlement mechanisms, some kind of politics, some kind of impartiality, some kind of different kinds of illegality will takes place in absence of institutional kind of mechanisms. That is the reason day by day, this kind of panchayat, settlement of elders, settlement of community elders, settlement of other people who are leading in the society and heading the political parties, that kind of mechanisms have day by day come down. And later, in international level, we had so many conventions have taken place. Very important conventions are Geneva Protocol Convention 1923, Geneva Convention on the Execution of Foreign Awards 1927, New York Convention of 1958. All these are conventions are discussing about importance of the arbitration. Suppose if any arbitration takes place outside the court, how we can legalize it, how we can enforce it, what is the validity of the award. If there is no legal touch to the those kind of awards, parties may not believe the system. That is the reason this is only alternative to the judiciary, not above the judiciary. That is very important. Alternative, all kind of alternative dispute resolutions are working under the judiciary control only. Because after completion of this kind of process, you must go and get approval from the judiciary for enforcement of awards. This is happening so many years. Coming to our Indian system, Indian Arbitration Act 1899 was there. Indian Arbitration Protocol and Convention Act 1937 is there. Arbitration Act 1940 is there. Foreign Awards Recognition and Enforcement Act 1961 is there. Legal Services Authority Act 1987 is there. UNCITRAL Model Law 1985. Finally, Arbitration and Conciliation Act 1996. All these legislations are very much responsible in the present developments of the arbitration. Coming to the Indian Arbitration Act 1899, this is brought by the English people. This is almost nearer to the old kind of mechanisms, and only village elders, community elders, family elders, political parties, head bodies, heads, all these people are involved in the system, and they will give their own kind of judgments in favor of husband, or suppose if since it is family matter, they may give judgment in favor of husband. Suppose landlords, suppose money lenders, these kind of things are happening. So much of partiality is taking place in this kind of things. That is the reason India day by day, our people are demanding for liberalization policies in India. And we requested, even in the British period also, we requested arbitration laws which are very much related to our Indian system, our Indian traditions, and etc. Finally, Arbitration Act 1940 came into force. Arbitration Act 1940 were in existence up to 1996 also. This is one of the traditional kind of mechanism, but Arbitration Act, no doubt, Arbitration Act we are practiced up to 1996. So many matters were settled outside the court also, but we don't have proper results. Proper quality kind of things are not happen. Most of the people are not affordable Arbitration Act 1940 because this is outdated Arbitration Act 1940. That is the reason people started not believing Arbitration Act 1940. And coming to the Foreign Awards Recognition Enforcement Act 1961, this is very important. Just now I spoke in the previous slide. So many international conventions have taken place in India, outside India also. India automatically became member in those conventions. That is the reason India started to accept enforcement of foreign arbiters before independence also. That is the reason we adopted all international conventions to enforce the foreign arbiter awards. This is very important. If you don't have this kind of enforcement mechanism, no party want to believe the arbitration system. That is the reason India started to respect international conventions since the beginning. That is the reason whatever the awards are came into force, we are respecting in India and enforcing in India also. That is the reason Foreign Awards Recognition and Enforcement Act 1961 we are following that act since today also. Legal Services Authority Act 1987, I will discuss after 5 minutes because why Legal Services Authority Act came into force. And coming to the UN Citral Model Law 1985, this is very much important model law in the settlement of commercial disputes which are related to arbitration. United Nations on International Commercial Arbitration Laws 1985 we had. India was the member. Before Model Law 1979 we got rules regulations of UN Citral Model Law. 1980, when you brought this kind of model law, when India became a member, automatically they directed all the members of the nations to go and follow UN Citral Model Law instead of which we had old law, that is in our India Arbitration Act 1940. Immediately our Indian government came to Indian government after coming back from UN Citral Model Law meeting. Immediately we appointed a committee to bring new law instead of Arbitration Act 1940. Immediately they started to bring new law, that is the Arbitration and Conciliation Act 1996 in the place of UN Citral Model Law. Now we are practicing 1996 arbitration law in the place of old law, that is Arbitration Act 1940. Now coming to the very important point. Why Indian government encouraging all these kind of policies in the arbitration system to settle the matters outside the court? Whether we have consent is there from the government of India or not. Coming to the new industrial economic policy in India. Yes, everybody knows economic liberalization started in India since 1991. Because of economic liberalization, increasing in foreign investment in India and Indian companies offering services and products to foreign companies, establishments of MNCs by establishing single window, attaching FDI in the Indian companies, attracting FDI in the Indian companies, establishment of WIPO, World Intellectual Property Organization, establishment of WTO in the place of GATT. When you have all these developments after 90s, you must expect, when you have these kind of important organizations, important developments after 1990s, you must have very good settlement mechanism. Disputes are inevitable. Disputes may come. If you take two persons, different opinions may come, different ideas may become. That is the reason to settle the matters amicably, we required very good mechanism. Suppose if you opt our regular court mechanism, suppose you take any money suit or any kind of thing, it is going several years. It is going several years because of this delay. So many losses are occurring to the parties, companies, and by seeing outside, GDP rate is also coming down because of this delay and everything. In some of the cases, suppose you take construction companies, suppose if anybody filed case in the court of regular court, if they got stay order, unnecessarily crores of rupees unnecessarily development will stop. Thousands of employees, laborers will come on the roads. If stay order comes, automatically everything go into the waste. That is the reason we required very good mechanism instead of regular courts mechanism. For that, we have consent from the government of India, assent from the judiciary also. That is the reason we started very good mechanisms like arbitration, mediation, conciliation, and negotiation. Because no doubt, after independence, after liberalization policies, when you have these kind of developments, suppose you take FDI, you take establishment of MNCs, so many things are happening in India. You take Hyderabad, Bangalore, Chennai, Delhi, so many multinational companies are coming. Suppose if you don't have this kind of mechanism, settle the matters outside the court, they may not come to India because they may say they may say your Indian mechanism, your Indian settlement mechanism is not good. That is the reason we don't want to establish any kind of companies. This kind of comments are given by multinational company chairmen also in one of the meetings. That is the reason when you are liberalizing policies are adopted. LPG, liberalization, privatization, globalization concept when you have, you must liberalize our Indian judiciary system also. That is the reason you must encourage arbitration, mediation, conciliation, negotiation, like anything to attract foreign investors to establish companies in our India. That is happening now because present government is encouraging like anything by establishing single window companies, single window system. Suppose if any foreigner comes to India, they are giving permissions in one day by with providing red carpet. They are providing lands without paying any money. Also, they are providing land because we have to provide employment to our Indian people like anything because of this liberalization policy, because of new industrial economic policy, our public sector undertaking companies were day by day closed down. That is the reason we automatically our employment is also come down. When you have this kind of bad systems, you must do this kind of systems in different way by providing employment. Because of these things are happen only MNCs are comes to India. That is happening, no doubt. Now coming to the justice delayed is justice denied. This is very important. Just now in our inaugural session, one of the speaker said 5 crores above cases are pending in Indian courts. Yes, no doubt, courts are pending, but we don't have proper mechanism to address the issues. There is no proper coordination between Supreme Court of India and Government of India. That these things are happening. This is one of the very important case in our Indian system That is Husainara cartoon versus State of Bihar 1979. This is turning point to the Indian judiciary because before 1979, any judge, you take any judge in the open court, they cannot open the mouth. If they open the mouth, some of the advocates may use different kind of words against the judges. That is the reason. Means some of the bad words means they are showing partiality to the petitioner, partiality to the respondent. These kind of bad words they use in the open courts also. That is the reason they could not open. Even judges could not open. Presiding officers could not open their mouths in the open courts. But after Husainara cartoon versus State of Bihar 1979, speedy disposal of the cases has become fundamental right. When speedy disposal of the cases has become fundamental right, they must encourage the parties to settle the matter. Judges cannot close the mouth. Now judges has to open the mouth and request the parties, demand the parties, counsel the parties to go and settle the matter outside the court settlement, and by appointing your advocate, by appointing arbitrator, mediator, negotiator, and you may depend on some other mechanisms. First, you must settle and come down to the court. We will close the issue. These kind of encouragements are coming from the regular courts now. For the effect of Legal Services Act 1987 came into force. For that, how can we? Yes, that those things must work under the judiciary. Then how it is possible? Now in each district court, now we have Legal Services Authority. Supreme Court also we have National Legal Services Authority. State level we have State Legal Services Authority. District level we have District Legal Services Authority. Mandal level, Taluka level we also Legal Services Authority Act 1987 came into force. Under this umbrella, so many services acts are came into, services authorities are came into force. Under this, they are conducting Lok Adalas. They are asking the parties to settle down the cases. Now here, after introduction of Lok Adalas, they are encouraging pre-litigation cases and post-litigation cases also. If both the parties want to settle the matter outside the court, now they can go and request the Legal Service Authority chairman to close the matter. Please dispose the matter as per this. What is your plea? Immediately, both the petitioner and respondent goes there. Automatically, is starting counseling and closing the matter by taking memorandum of understanding of the parties. Memorandum of understanding of the parties only becomes decree of the court. And if you settle the matter before the Legal Services Authority, there is no appealable also. What is the reason? After introduction of Legal Services Authority, these things are happening, and parties are without much money, without any expense, they are settling the matter before the chairman Legal Services Authority also. Now, pre-litigation cases. Coming to the post-litigation cases. Suppose if any party, if already filed a case in the regular court, now you can request the judge to transfer particular case to Lok Adalat for settlement of the dispute. On the request basis also, the regular judge may transfer that case to concerned Legal Services Authority chairman. Again, he will call the parties and counsel the parties, settle the matter there itself by taking memorandum of understanding. That memorandum of understanding only part of decree also. After settling the matter, simply is again sent back to the regular courts for want of scrutiny and want of pass court decree. This is happening in the case of post-litigation cases. That is the reason Lok Adalat's concept has become wonderful, successfully working in India. Not only settling the matters, in some of the cases, telephone issues, electricity issues, insurance issues, whatever the issues are there, companies and private parties and other important organizations are approaching Lok Adalas, settling their matters there itself. And coming to the family courts, yes, after introduction of family courts, for counseling point of view, family court judges are sending the matter to counselators, and they are calling the matters. They're starting saying the importance of the marriage, importance of the custody, property settlement, and custody of the children, everything happening outside the family court only. After settling the matters, if counselor, they will send back to the settlement of the issues again to the family court judge. Based on that, he will passing the decree in family courts also. Without wasting much time, these things are happening in the family court also. Coming to the Consumer Protection Act, even after 1986, when consumer courts are came to force, if any disputes are there, they are settling outside the court by establishing local adalats there itself, and mobile local adalats also they started now. If any organization, if they go and request the local judge, they will request they will appointing some other advocates to go and settle the matter there itself. Those people are those panel of advocates are working under the umbrella of local adalats, and whatever the settlements happened by the advocate panels, that is also equals to the court decree and judgment also. These things are happening under the umbrella of consumer courts, family courts, and outside some of the organizations working for the settlement of disputes by taking help of the local adalats. Coming to the very important, that is a very important thing in the Indian system is the Civil Procedure Code. We introduced Section 89 of CPC in the year 89 of CPC in the year 1999. Section 89 clearly shows whatever the matters are there in the court, we can settle the outside of the court, and otherwise also you can use Section 89 to settle the matter outside the court also. After introduction of this Section 89, so much of hesitations are happened in the open courts, and high courts, district courts, taluka courts, and even Supreme Court advocates also hesitated to brought Section 89 CPC for settlement of the disputes outside the court. Because if you brought this kind of mechanism, day by day, advocates practice may be come down. This is a very big threat to the advocates. That is the reason most of the above 50% of the advocates are hesitated to brought Section 89 CPC to settle the matter outside the court. Outside the court. That is the reason Salem Advocates Association filed a writ petition in the Chennai. The matter again went to Supreme Court. After hearing both the parties, finally Supreme Court given assent to the government of India to brought Section 89 because of Hussein Ara Alam case, that is speedy disposal of the cases already we had, and that is the reason you must respect Supreme Court judgment. When you brought speedy disposal of the cases under Article 21 of the Indian Constitution, automatically we have to respect that judgment, and Indian government respected and brought Section 89. Besides this, very important is that Section Article 39A also, that is equal justice and free legal aid to the poor people also that we had. That is the reason, suppose if any ex-person is there, he cannot pay more money to the advocates because court litigation has become more costlier than settlement of the cases outside the court. That is the reason we have to see the poor people of India also. Some of the sections people are depriving so many benefits in the society. Because of the reason, if they involved in any legal litigation, they cannot affordable any kind of advocates because they are asking lakhs, thousands, and we are hearing in the Supreme Court, some of the advocates are taking crores of rupees to argue the cases. Just to imagine how judiciary went to asking fees from the clients. This is very difficult to common man. That is the reason Krishna Iyer and other important judges who were in the Supreme Court 1970s, even they are also said, if you lost faith on the judiciary, we cannot survive in the society, because people must respect the judiciary, must believe the judiciary system, then only we will survive, otherwise no. That is the reason immediately they activated Article 39A, because of 39A, they started provide free legal aid to the poor people by under the umbrella of Legal Services Authority Act. Suppose if any poor people goes to Legal Services Authority Act, they are appointing one advocate. That advocate is taking care of poor people cases on free of cost. That is the reason we are respecting 39A also. Besides that, the establishment of the International Center for Alternative Disputes Resolution, ICADR. Actually, we had in the ICADR in Hyderabad, Gagan Mahal. Because of so many reasons, now it is not operating. Because of international developments and after bringing UN Citral model guidelines in our India, after appointing to brought Arbitration Conciliation Act 1996, immediately we brought Center for Alternative Dispute Resolution, ICADR. This is independent non-profit making body. Actually, originally head office was located in Delhi. Brought in the year 1995. Very significant importance is there for this institution. Whenever the matters are there, you can go and file the matters in ICADR. ICADR not only settling the matters, they are conducting certificate courses, diploma courses, and some other important things which are very much related to the people, awareness and etc. This is good law that is responsive to both domestic and international requirements. These kind of institutional arbitration centers like ICADR, these are not only encouraging domestic, they are also encouraging international awards and domestic awards also. And ICADR is honest and competent arbitrators and conciliators without whom any law and arbitration or conciliation can succeed. Availability of modern facilities and services such as meeting rooms, communication facilities, administrative and secretariat services, everything happened in the ICADR center. Because of, I don't know what are the reasons behind non-operation. Now ICADR center is not operating, not only in Hyderabad, even in Delhi also. Now coming to the ADR in India. The Indian legal framework through section 89 of CPC promotes use of alternative disputes resolution between the parties. Just now I said section 89 is very important because people are saying that settlement of arbitration is purely private. Yes, no doubt it is private. You can appoint arbitrator outside without consultation of the regular court also, but respecting award, you must do regular courts, filing EP or getting decree or any kind of thing from regular court or Lok Adalat only. That is very important. Not only section 89 of CPC, Order 10 Rule 1A confers powers on the court to direct the parties to choose any alternative disputes resolution method to settle its disputes. This can include ODR as well also. You know, most nowadays, not only ADR, we had ODR also, online disputes resolution mechanism also, like ADRs, because after introduction of information technology law in India, because wherever you go, e-governance, e-disputes, e-settlement, e-payment, everything is happening through E only. That is the reason why not to develop ODRs. As on today, in India, we don't have any ODR separate laws. Even we are settling ODRs through using information technology law. Now settlements are happened. Now so many private organizations are came to settle the ODR issues also. Even I am also member in the ODR ways, some organizations to settle the matters. What happened in the ODR? Simply they are sending the matters to the members who are enrolled under ODR ways. These people are settling the matters, sitting in the residence without disturbing their actual work. Simply they are sending awards to the companies, getting money from the companies also. This is happening from the ODR ways. Let's now look at some specific ODR follows the, just now I said, Arbitration and Conciliation Act 1990, just now I said, it is settling domestic as well as international commercial arbitration. State of Maharashtra versus Dr. Praful. This is very important case. Video conferencing record also valid in the court of law. Suppose if you settle the matters through ODR by adopting virtual kind of thing, video conferencing, whether video conferencing, virtual kind of things are valid or not in India. This is one of the very big doubt to the more participants, I think. In India, one of the case, that is state of Maharashtra versus Dr. Praful. And in this case, Supreme Court clearly said, video conferencing to record witness statements and video conferencing settling the matters through computers and internet by using all these kind of mechanisms. These methods are valid in the court of law. At that time, only one important thing is there. You must utilize your email as original platform, then only it is valid. Suppose you cannot blame any other other party after getting awards. That is the reason by using your original email, that is through email only everything must possible. And when you are going to settling the matters through ODR, you must send documents, scanned documents through your email. Then automatically other party feels it is original. Whatever the documents you are sending through emails, automatically as per section 31 of Arbitration Act also, once you exchange the documents from your email to other party email to your email, those documents you feel that you must say that those documents are valid in the court of law, and you can say that original documents. And constitutional mandate and ADR method. This is very, very important. 1940 was a good piece of legislation, but it was considered to be ineffective. I said, because so much of literacy developed in our India day by day, and everybody wants to speedy disposal of the cases, speedy kind of thing they require. And also you come into the judiciary, if you file case today, some of the instances are there in Hyderabad, 40 years, 60 years, 50 years also, these matters are going in the case of land disputes, money suits, and etc. etc. That is the reason our Indian people day by day, they are losing confidence on the regular kind of judicial system. That is the reason Supreme Court in one of the cases, Guru Nanak Foundation versus, please note down, Guru Nanak Foundation versus Ratan Singh and Sons, 1981. This is very important. 1979 Hussainiana Cartoon case, 1981 Guru Nanak Foundation versus Ratan Singh. In this case, the Supreme Court clearly said, in open court, the Supreme Court judge said, the 1940 Act was ineffective, and the way the proceedings under this Act were conducted in the courts made the lawyers laugh and the legal philosophers weep. This was commented by Supreme Court judge in the Guru Nanak case. That is the reason India, after observing this case, India started thinking in positive way. Automatically, they involved in the 1985 case, attended, brought so many guidelines, new changes have happened, and immediately they brought wonderful legislation, that is Arbitration and Conciliation Act 1996. It is settled law that free legal aid to indigenous persons who cannot defend themselves in a court of law is a constitutional mandate under Article 39A, and 21 of the Indian Constitution. The right to life is guaranteed by Article 21 of the Indian Constitution. You know, in most of the cases, suppose if any pensioner files case after his death, courts are settling the matters. He is losing his fundamental right. Not only fundamental right, he is also losing right to life, which is guaranteed under Article 21 of the Indian Constitution. That is very important. Just now I said scanned copies also you can send to other party when you settle the matter online also. And a very important case, very important case, Shakti Bhog Foods Limited versus Kola Shipping Company Limited, 2009. In this case, Apex Court clearly said, whatever the documents which are sending to online by scanning, those documents are feel that original. Suppose if any dispute arises in the case of marking of the documents, you may raise the question through video conferencing only. That is only the method. Otherwise, you have to feel that whatever the documents sent by the other party, those documents are original, and you can defend and you can cross there itself by giving objections in the open court also. Then the effective consultation can be achieved by the resort of electronic media and remote conferencing. It is not necessary that the two persons required to act in consultation with each other must necessarily sit together at one place unless it is the requirement of law or the ruling of contract between the parties. You know, here when you settle the matters through online dispute resolution, instead of two persons, now we require third person who is service provider, and he will coordinate in between the parties who are sitting different places. One person may sit in Berhampur, one person may sit in Delhi, and service provider may sit in Hyderabad. Now you can settle the matters through online amicably without any disturbing legally. Those are valid as and today, which are judgments are given by the Supreme Court only. Now, disputes resolution India. Primary object of ADR system is avoidance of excession, expense, and delay, and promotion of the ideal of access to justice. This is very important. You are losing after independence to some extent, that is up to 1980s. People are day by day, they are losing confidence on the judiciary. Suppose if you go and file the cases in the judiciary, the matters are going several years, several decades. Instead of that, is there any mechanism or not? In our Indian Constitution, we had very important thing is that access to justice. When your access to justice system is there, why not our people or our judiciary is thinking in different way, like UK, US, and some other countries which are already adopting new kind of mechanism to settle the matters outside the court. Suppose coming to the access to justice, you can divide into two parts. Normal disputes resolution. Normal dispute resolution that you can say that judicial and quasi-judicial mechanisms, that is courts and tribunals. In this case, we are appointing regular judges. We have procedural laws, CPC, CRPC, evidence, and we are adopting. We are following these rules, regulations as per law, and settling the matters by giving respect to other party, by sending notices, and after hearing both the parties as per CPC rules, we are settling the matters in the regular course. Coming to the alternative disputes resolution, arbitration, mediation, conciliation, Lok Adalats, panchayats, family courts, consumer courts, etc. We are using services. We are giving services on the name of alternative disputes resolution. In these cases, we are not following CPC, CPC evidence also. We forget about CRPC because we are not considering any criminal case under arbitration. That is the reason you take second one, alternative disputes resolution. Arbitration, mediation, conciliation, Lok Adalats, panchayats, family courts, consumer courts. whatever the courts are there than judiciary. We are following alternative dispute resolution mechanisms. But in absence of CPC and evidence, this is very important. And you may ask one question. Suppose if any important issue is there, how can? Immediately presiding officer or president of the consumer forum or any person who is dealing the alternative disputes resolution mechanism systems, those people must follow CPC guidelines in the absence of original sections, orders, and etc. That is very important. Coming to the very important thing, we don't have any criminal law provisions in the Arbitration Act. After passing a final order, if other party not respecting, then you can go for execution petition by adopting CPC. But we are not saying any CPC rules orders in that petition. And coming to the ex parte decree, ex parte order in the consumer forum, we don't have Consumer Act not discussed about about any ex parte orders. Suppose if any ex parte order passed by consumer forum, now you can file 151 CPC petition by saying set aside the petition. This is happening by following some of the orders in absence of the regular legislation like consumer, loc others, conciliation proceeding, institutional kind of things. When these things are absent, we are following CPC rules also. Not strictly, that is very important. Courts will overburden India, no doubt. Just now, our even in inaugural session also said, but in the July in the Parliament, Ram Meghwal said, Arjun Ram Meghwal, law minister, he said 5.2 crore cases were pending in various courts in India. The Supreme Court, the 25 high courts and subordinate courts we had. Instead of all these establishments, also we overburden 5.2 crores. Who are the responsible for that? This is very important. Here, so many discussions are coming into force. I will discuss after some time. Total number of cases pending in the high courts and the district and subordinate courts as on July 14 are 60,62,953 and 4 courts 41 lakhs 35,000 4 courts 41 lakhs 35,000 respectively as per the information made available on National Judicial Data Grid NJDG. As per NJDG, these much of cases are pending in different courts. That is the reason why. Who are the responsible? Only one answer is there: no proper recruitment as per the ratio of the people. That is very important. These present system of appointment are happening 1980, 1971 census. They are not happening latest census. That is very important. 27% of cases are disposing every year. Suppose you take 2023. If you file 100 cases, our courts are disposing only 27% of the cases. That is the very important thing. Why they are disposing 27% means what they are saying, we don't have this facility, we don't have that facility, we don't have clerks, we don't have steno, we don't have attender, we don't have infrastructure, we don't have internet, we don't have this, we don't have that. These kind of concepts are regularly given by judiciary. Lack of infrastructure, lack of training. This is very important. They are simply appointing judges, but they are not giving proper training because cyber crime is there. Most of the judges in India, they are not aware. They are not aware information technology, computer, and languages which we have in using computers, and they don't know how to use the computers because they appointed long back. Now so many changes have happened. Governments are fails to give proper training to them, and that is very important. And coming to the lack of coordination between prosecution and police and judiciary, this is very important. Suppose today one case filed, this investigating officer has issued FIR and filed charge sheet in the court of law. Immediately is transferred to some other place. After 2-3 years, this case may come for trial. At that time, he may be posted somewhere. He may be busy somewhere. Higher ups may not give leaves. They are gone taking dates because of on that issue. One day, if we come, they are depending on constables. They are depending on constables which are there to handle the files, clerks, and some other lower graded people. They are depending on lower grade people. This is happening in the especially in the criminal law system, because we can say that there is no coordination. That is the reason what I am suggesting. Directorate of prosecution must be different department from the police department. This is not happening in India. In most of the states, prosecution is under the police department. This is very bad. Immediately we have to delink from the prosecution and as well as the judiciary. Suppose if they have autonomy, they can work their own way, because after filing charge sheet, investigating officer may hand over the file to prosecution, director of prosecution. They will appoint technical persons. They may take a technical opinion, because nowadays day by day cyber law cases are going up, and investigations are taking different way, because out of 100 cyber law cases, only 5-6% of the conviction rate is there. That is very bad. You can assume that out of 100 cases, 5-6 conviction means you can say directly that we are weak. Means government is weak to investigate the cases properly. That is the reason advocate defense counsel are taking advantage, and they are winning the cases by adopting loopholes from the prosecution side. That is the reason we required prosecution, police, and judiciary coordination is very important. Then only we can dispose the cases immediately. And just now I said no training on cyber laws, cyber crime, cyber frauds, and investigation, etc., etc. We are encouraging online. We are encouraging e kind of things like anything in India. But one way we are encouraging, other way we are missing the coordination in between the encouragement percentage and trial and judicial and prosecution level 0, because most of the place out of 100, you can say 90% of the police officials they don't know cyber crime, they don't do cyber investigation process. Only you can say 5-6% of people are aware about information technology, cyber crime, cyber law, because they don't have mechanism to identify BTech background people, cyber law known people. They are not appointing law graduates to do only these kind of cases and etc. This is lacking. That is very important. That is the reason in future, if any notification or appointment of investigation and filing charge sheet, they require specialized graduates from law department and engineering and other kind of persons who are dealing cyber laws. That is very, very important. Coming to the role of ADRs in India, you know, ADR system is very, very flexibility that is there. Because of this flexibility only we are encouraging, but we are not with giving respect to the regular kind of things. We are giving so much of respect to CPC, CRPC, regular courts. We are also encouraging ADRs. Procedure is very flexible. You can save valuable time. You can save valuable money. You can avoid the stress and conventional trial. This is very, very important. Suppose if because of bad luck or something, if anybody filed a case against you, you have to move every week, every month. Simply they are giving dates. Go and present before the judge. Again, he will give next date. Witness present. IO absent. Other party absent. Counter not filed. He is held up in the traffic. He is not officially held up in the meeting. So many this kind of exceptions are there. They are taking all these kind of things and delaying matter in the regular course. To avoid this kind of thing, now we are encouraging arbitration system. Day by day, we are losing confidence on judiciary because just now I said, Supreme Court judges are taking crores of rupees as fees, crores of rupees for one instance. Harish Salve, just after my class, just you click in the Google, how much tax paid by Harish Salve in the year 2022-23. Just you imagine how much money he is earning. I'm not saying why he is earning money, but is also for social services point of view also is there, and even he taken 1 rupee from the government of India also. But at the same time, every advocate must think like Harish Salve. Then only in the case of Arbushan case, he taken only 1 rupee from the government of India. That is also there. Now he is member in the general elections panel also. Now coming to the very important thing is that judiciary must lose confidence from the general public. This is very important. If you lose confidence on the judiciary, all the mechanisms will collapse. That is our concern. Even law professors, law lecturers must work towards bring confidence on the judiciary. That is very important. Suppose if you start losing confidence on the judiciary, you forget about the system and unruly will come into the picture. That is the reason. Start saying the very important thing about judiciary and at the same time you have to encourage, you have to start saying so many things to the government to adopt these kind of methods and appoint judges, provide infrastructure, provide this kind of facilities to the judges, etc., etc. Then only our system will otherwise collapse will come into the picture. What are the advantages of the ADR? It can be used at any time. That is there. There is no 10 to 5. There is no any kind of formalities. You can use arbitration in any time at 10 to, even in night 12 o'clock also. Reduces the number of contentious issues. Yes. Once parties are sitting together before the arbitrator who appoints by both the parties, that is very, very important. After getting consensus, that is very, very important. After getting consensus only, after getting consensus from both the parties, arbitrator appointment question will come into the picture. That is the reason after appointing arbitrator, automatically so many contentious issues will come down. That is very important. Arbitration costs less than regular litigation. That is there. That is depends upon the parties only. They can settle the matter in one sitting, so 2 sittings also. Unnecessarily, if you go more than 2 sittings, 3 sittings, cost will go into the picture. That is the reason parties knows if you go 2-3 hearings, what happens and everything they know. That is the reason they are settling the matters 1 or 2 sittings there itself. It is very flexible. You can conduct the proceedings in any advocate chamber. You can conduct the proceedings Star Hotel. You can conduct the proceedings anywhere. Anywhere. There is no any bar. If parties must agree, then automatically arbitrator go and settle the matter wherever they want. It helps in reduction of workload of course. Actually, this is the crux of the problem. Why courts are encouraging? Why Indian government is encouraging? Indian government is not in a position to appoint so many advocates, so many judges immediately. Indian government fails to provide infrastructure properly. Indian government fails to do so many things what they are demanding. Recently, N.V. Ramana was there. He started infrastructure kind of meetings and given report to the government of India also. It is not work out. It helps reduction of workload of the courts. It can be used at any time, even when a case is pending before court of law. This is very important. There is no bar at all. Suppose one case is pending before civil court. Already they given October date. Before October date also, if parties wants to settle the matter, they can go and sit somewhere by appointing arbitrator, mediator, negotiator. This is the case, this is the issue, this is the thing. We have to settle the matter. Suppose if they settle the matter outside the court, immediately they have to enter into the MOU, Memorandum of Understanding. Terms and conditions they must write in that one. Same kind of thing must sign by the both the parties, and that document must file in the October date. Automatically, regular judge will respect the settlement which are taken outside the court, and immediately he will pass the decree in that particular case that is happening. Even you can find disadvantages also. ADR may not be appropriate. No doubt, here what happened, no doubt, arbitrator is private judge. Arbitrator can call as private judge. Arbitration is private. When these two things are there, it's not appropriate because they are not following any CPC, CRP, evidence and other procedural laws and other legislations. Whatever they want, they can settle the matter by giving decree. Even they don't have any pro forma for judgment also. Even they don't have any pro forma for model form of giving award. Simply they can write on the paper and sign. That will become award of the issue. That is the reason it may not be appropriate for in some cases. By seeing outside also, people feel that if regular court settles, the meaning may be different and issue may be different. But we want some of the cases, very less people are, very 5-6% of people are opinion that if settle the matter in regular court that is different from ADR and etc. May even carry a degree of risk for one of the parties that is there. Suppose we are all human beings. We are all human beings. We are working for the system. When you are appointed as an arbitrator, nowadays we are listening in the newspapers, TVs, and other comments. Judges are working for particular system, particular community, particular caste, particular region, particular religion, particular place, particular this kind of thing. Even today, 10 days back, Hindu paper clearly mentioned third judge of the Supreme Court as relation to retired Supreme Court judge and brother-in-law of retired Supreme Court judge, son-in-law of retired Supreme Court judge, and these kind of comments are coming also. In most of the cases, Supreme Court courts are appointing retired Supreme Court judges as arbitrators, retired High Court judges are arbitrators in most of the cases happening. When you have this kind of comment, why not you think here some of the degree of risk is there in favor of one party? Chances are there because we are all human beings. That is very important. Imbalance of power between the parties which could make face-to-face mediation unfair. In most of the cases, what happens, suppose if in open court, when chief examination, cross-examination is there, in cross-examination, you can find some very numerous important points from the client by asking cross-examination questions. But in the case of arbitration, there is no cross-examination. Arbitrator must depend on documents supplied by both the parties. 100% he will go whatever the parties says to the arbitrator. They cannot go beyond contentious points and etc. That is the reason in most of the cases arbitrator will depend on the documents. So there is no cross examination and etc. That is very important. May even carry a okay right imbalance power between the parties, which could make face to face mediation unfair. What are the disadvantages? Continuously, legal rights of human rights cannot be relied on in ADR process. That is there. You don't expect legal rights and human rights. That is very important. And ombudsman investigation can be very slow, relatively less structured. No doubt we are saying that no CPC, no evidence, nothing. Whatever they want, they can follow, they can write on the paper. Whatever they write, that will become order, judgment, decree, that's all. They can issue interim relief orders also uh, by by reading the petitions. If any urgency is there, they are giving interim relief to the parties also. No concept of legal proceedings. Resolution not guaranteed. No suitable if there is a question of law. When question of law is there, especially in the question of law, High Court and Supreme Court can decide the matter. But when question of law arises before the arbitrator, he is not the suitable person to, because he is private person, he is private judge, he cannot decide question of law. Question of law decided by Supreme Court, High Courts by getting counters, explanations from the government of India and state government. That is only possible, otherwise no. Next, possibility of undue influence. Just now I said what is going in the India, what are the things are appearing in the newspaper, at TVs, and even in one MP from Kerala, he openly said in the parliament that these kind of appointments are happening in the judiciary. That is the reason, even in my case also, I am losing confidence on the judiciary because of these appointments and etc. That is the reason arbitration lacks granting permanent injunction and specific performance. Possibility of undue influence is there. They cannot arbitrator may give interim direction for both the parties, but arbitration cannot give permanent injunction, specific performance like regular courts as per CPC and etc. The cost can be major problem if fails to complete within the time. Here, very important thing is that we appointed arbitrator for 2-3 hearings. Now, after 2-3 hearings, clearly he says, I will charge again other 50,000. After 3-4 hearings, I will charge 50,000, 1 lakh also. That kind of agreement will be there in the case of appointment of arbitrator. When you have this kind of agreement, that is the reason, suppose in some of the cases fails to complete the process in 2-3 adjournments as per agreement by the parties in appointment of arbitrator, automatically he will charge more. That may not happen in the regular courts. That is very important. No appeal can be made for an arbitrator order granted by the arbitrator. This is there. In the case of arbitrator, we cannot file appeal in most 99% cases. In 1% case, we can file because of lack of confidentiality, lack of some other fraud cases, and arbitrator may involve in the criminal nature, insolvency, and some other issues. You can ask regular court to terminate his appointment, and some other issues will come by whenever illegality come. You can ask regular arbitrator to not to proceed further. This is very important. Coming to the types of arbitration, this is also very important. Domestic arbitration, international arbitration, foreign arbitration, institutional arbitration, specialized arbitration, ad hoc arbitration, statutory arbitration, fast track arbitration, or mid arbitration, court annexed arbitration. We have 10 kinds of arbitration methods are there. Most famous arbitration is domestic arbitration and institutional arbitration. In the case of domestic arbitration, both the parties must belong to India settle the matter as per the Indian legislations, and if any issue comes, execution and other kind of things will decide by the Indian laws. That is the reason we can call it as domestic arbitration. International arbitration. One party must from the outside India. Things are same like domestic arbitration, but in the case of international, other party must be outside India, maybe UK, US, Sri Lanka, some other country. Automatically, if things are happened, we are calling it as an international arbitration. Foreign arbitration means without Indian involvement, things are happen outside India. Outside India means UK, US. If parties get any kind of award, if they brought to India, we can respect that award by Indian laws, by translation, and our Indian laws respect. It is not against the public policy. Automatically, we will respect even foreign arbitration awards also. Institutional arbitration means Indian Institute of Commerce, Indian Institute of Indian Institute of Corporate Affairs. Even recently in Hyderabad, Gujarat also, N.V. Ramana introduced some international organizations. Those are institutional arbitration. They have their own rules for disposal of the arbitration cases. Even Telangana government also sending some matters to international commercial arbitration, which are established by Justice Ramana. After deciding that only, they are filing the counters and some other legal opinions. Everything happened by sending the matters to International Commercial Arbitration Center. They are taking care of domestic as well as international commercial arbitration. Specialized arbitration. Specialized arbitration is very important. In some of the cases, construction contracts, architecture contracts, and family matters, specifically they will settle the matter. They specialized in particular area. Suppose construction contracts. Construction area is one of the very big area in the arbitration. Most of the cases they will file under arbitration because specifications and deviations and rates which are given in the agreement. Any deviations will take place. They are filing the cases under arbitration mechanism. Those issues are comes under specialized arbitration. Ad hoc arbitration, you can sit anywhere, no rule, no method, no procedure. Whatever arbitrator wants to settle, that is called as ad hoc arbitration. Statutory arbitration means as per law, as per legislation, as per statutory provisions, if they decide, that is called as statutory arbitration. Fast track arbitration, this may decide in 15-30 days by using documents which are supplied by the parties. Med arbitration. This is very, nowadays it has become just little famous. Whatever the issue are there, it may be arbitration, sometimes mediation, sometimes mixed kind of thing. They can settling the matters. That those kind of things are, we are calling it as bed arbitration. Court annexed arbitration. This is very important. Just now I said, but I did not give a name for that. Judges who are sitting in the regular courts, when parties are ready to settle the matter outside the courts, based on request of the parties, if regular judge send the matter outside the court, that is local adalat, that is called as court annexed arbitration. Means regular main case may be list in the regular court, main case may be given dates by the regular courts, and things are happen in the legal service authority under local adalat and other kind of things by appointing experts and everything. That is called as court annexed arbitration. Coming to the section 7. Section 7 is arbitration agreement. Whatever things are I said now, everything is based on arbitration agreement. See, you may ask one question, agreement is compulsory or not? Agreement is not compulsory in the arbitration. But orally also they can speak, they can enter into agreement. based on their phase, based on their understanding, they can proceed further. Section 5, court can Section 5 speaks about definition of agreement, and Section 7 speaks about court can interfere in the arbitration proceedings. Section 2B defines agreement. Section 7 deals about essentials of arbitration agreement. Here, very important thing is that as per our Indian Contract Act, what is agreement? Same definition will come into Section 7 of Arbitration Conciliation Act 1996. There is no any other kind of definitions. You have to follow Indian Contract Act 1872 regarding arbitration agreement, contract, essentials of valid contract, enforcement of contract, minority, undue influence, and legality of the object, consideration, everything. Whatever section 1 to 75 are there, all 1 to 75 sections are very much relevant in the case of section 7 of the Arbitration Conciliation Act. 7 is very important. If there is no agreement, arbitrator cannot move forward, because everything depends on arbitration agreement only. Persons who are completed LLM corporate law, who are expert in the Indian Contract Act, they can adopt new kind of profession, that is contract administrator. Nowadays in Hyderabad, Delhi and metropolitan areas, new kind of profession has come, that is contract administrator. Means so many people are going for arbitration, but in the main objective, very primary objective in the arbitration is that very first question is they are asking whether you have arbitration or not. Whether you have arbitration agreement or not. Here, arbitration agreement is not different from other kind of agreement. As per Indian Contract Act 1872, what is the definition? What are the essentials of agreement? What is contract? What are the essentials of valid contract? Everything is same as which are mentioned in the Indian Contract Act 1872 only. 1 to 75, just you go through, and you may become you can adapt new profession, that is contract administrator. Very important profession. After retirement as professor, you can go for chamber practice by choosing contract administrator, because so many companies are coming to your office, may come to your office for writing of arbitration agreements. That is very important. Capacity to contract and everything is like Indian Contract Act 1872 only. And Raju versus Raju 2000, if there is no objection either party, court can appoint arbitrator. Here very important. After filing ex parte in the court for appointment of arbitrator, if Y party said no objection, automatically court may appoint. Otherwise, you can mention name of the arbitrator, qualification of the arbitrator, place of the arbitrator, number of arbitration, everything in the agreement. As per the agreement, both the parties must follow, and whatever the defense, whatever the counterclaim given by the parties, that is very important. Here agreement is optional. Just now I said agreement is optional, but nowadays you can. This is only academic point of view. I am saying agreement is optional, but without agreement, arbitrator cannot move further, because we can work on agreement only. That is the reason before going further, any kind of development, any kind of activity, any kind of transaction, whether it is civil contract, whether it is construction contract, whatever the civil nature of thing, you must go for contract agreement only. Because today you may be friends, tomorrow because of developments in the market, economic developments in the society, so many things will come in different way. For that we want one arbitrator, private judge to settle the matter. We are calling him as arbitrator, mediator, negotiator, etc. Coming to the section 8, power of the court to refer disputes, that is there. Section 9 of the Act, interim measures, just now I said, even arbitrators can direct the parties to not to proceed, not to sell, not to work, not to make payment. These kind of interim measures, they may direct the parties to respect the things. And appointing receivers, this is also very important. Appointing experts, appointing surveyors, attaching property. All these kind of directions may given by interim by arbitrators, except the perpetual injection and specific, etc. Coming to the tribunal, what is tribunal? Tribunal name itself more than two. Section 10 of Arbitration Conciliation Act 1996 says number of arbitrators and sole arbitrator. You know, Narayana Prasad Lohia versus Nikunj Kumar Lohia 2002. It speaks about appointment of number of arbitrators. In some of the cases, even sole arbitrator also you can call it as tribunal. In some of the cases, more than two. Third person will appoint by the these present two arbitrators. Then third person will, after appointing, third person will act as presiding officer. Then we are calling these three people are tribunal, arbitration tribunal, as per section 10. Section 11 appoints the arbitrator. In the case of appoint arbitrator, first of all, nationality is very important. Majority is very important. Presiding officer capabilities must have. Chief Justice of High Court or Supreme Court may them appoint within 30 days after filing the case. Jurisdiction of the tribunal as per the agreement. This is very important. Most of the students are raising this question. What is the jurisdiction? Jurisdiction, everything, jurisdiction, appointment, and whom you appoint, where you appoint, how much money you have to pay, everything you must write in the agreement itself by way of clauses. Nowadays, we had section 10 of Indian Contract Act, 10 essentials. Now you can say one more essential, that is arbitration clause. Arbitration clause is also very important in the arbitration agreement. Besides arbitration clause, we can find out who will be the judge, how many hearings should be required, fees we must pay, where should we file, whom should approach, what are the dates, everything you must write in the arbitration clause. That is becomes call it as jurisdiction and everything. Qualifications of the arbitrator will decide by the agreement only. This is very important. Suppose your issue is related to construction activity. You may appoint civil engineer who works for 30 years in the government department. That is only the big qualification. And 30 years of civil engineering is better judge than Supreme Court sitting judge in the present case, because it is construction activity case. Construction activity case decided by civil engineer who works 30 years in the particular industry. As a professor of law, I can say that sitting judge of Supreme Court, he knows CPC, CRPC evidence better than civil engineering. But he don't know what are the important things which are involved in the civil contract and etc. That is the reason this is so much of flexibility is there in the appointment of arbitrator also. That is the reason we are giving autonomy to the parties to appoint arbitrator based on problem which is there. That is very important. Powers of the arbitrator: perform contract, power to take assistance, administrative help, own jurisdiction as per 16, interim relief as per 17, procedure to follow 19, no specific location, language, they may adapt to English, Telugu, Malayalam, Oriya, whatever they want, they can adapt language. Translation, this is very important. Proceedings may take place Oriya, but after getting decree, for execution point of view, you must translate Oriya language to English, because our court language is English. Whenever you go for execution, courts are asking English document only. That is the reason official translator, we must identify official translators. After Oriya document, you have to translate into English. Official translator will translate that Oriya language to English. Then you can submit to the court, district court. they will execute the document as per the CPC proceedings only. Termination action of the parties, appoint expert opinion like CA. Suppose chartered accounts problem is there, you can appoint CA. Company secretary issue is there, you can appoint company secretary. Any bank issue is there, you can appoint banker as an expert. Like that, you can appoint any person for taking assistance from the experts. Just now I said one land issue is there. Survey problem is there. You can appoint surveyor and take assistance, court assistance also very important. Coming to the functions of the arbitrator. Within the scope of the agreement, they must work. They cannot go beyond the agreement because agreement is there. Suppose in absence of agreement, they can go beyond the oral agreement also. That is the reason most of the cases agreement is very important. Just again I am repeating, now contract administration has become more popular profession now. They are paying lakhs of rupees as fees to the agreement holders because so much of technicalities will be there. Tomorrow after writing the agreement, courts may not attract any kind of deficiencies in that. That is the reason contract law related professors may choose contract administration positions. Section 14 and 15 relieve from the duties with valid reasons, conflict of interest and everything. Suppose as per section 14-15, arbitrator may relieve because one of the receiver, one of the party distant relative is if he is related to your brother-in-law, any family relations, any kind of religion relations, if you feel immediately you have to withdraw from the execution of the decree and withdraw from the proceedings of the arbitration and etc. Acting as per the section rules, section 28 of the Arbitration Conciliation Act 1996, section 28 terms of the contract and accordance with the applicable rules that is there. Section 28 take into account of the terms of the contract and trade usage applicable to the transaction. Suppose while doing any kind of arbitration work, suppose if you appoint, you have every right because you are equals to district judge. When you have autonomy also there. When you are appointed some worker or workforce or for betterment of purpose, you must follow trade usage applicable rules which are there in the city. Otherwise, suppose if you want to pay something, don't pay any less amount because as per minimum wages, what are the things are there, what are the money is there, you have to pay to the people because you have to follow certain usage applicable rules and etc. Section 30, Section 30 encourages the parties to settle the arbitration mediation while going arbitration issue. They can go for mediation and conciliation for speedy disposal of also. The arbitrator have every right to terminate the award proceedings because if he feels any inconvenient, because if he feels any illegality while executing the proceedings, while doing something for betterment of the arbitration proceedings, etc., something happened, immediately they may go for termination of the award. And section 34, public policy of the country. Whatever I said now, whatever the things are there, whether it is foreign, whether it is India, whether it is any kind of thing, if it is against the public policy of the country, you cannot execute, you cannot go for arbitration. That agreement, that law must be within the purview of the Indian legislations, within the purview of the court only. Whatever the agreements are there, that agreement must be enforceable in the court of law. Then only that is valid for execution. Otherwise, you cannot execute the whatever you cannot execute the problems what you want. That is very important. Finally, you can say that public policy of the country is very important. Those issues must executable in the court of law like Indian Contract Act. Challenging of the appointment, independence and impartiality should be there. That is very difficult to find out nowadays. Not qualified as per the agreement, unable to perform function, fails to act in time, withdraws voluntarily, mutual agreement of parties, court action. In above 7 points, you can you better to not to appoint, better not to appoint arbitrators, because if when he is not independent, when he is not impartiality, don't appoint. When he is not qualified as per your agreement, don't appoint. When he is unable to perform function, don't appoint. When he fails to act in time, don't appoint. When withdraws voluntarily, immediately ask him to get out. Mutual agreement of the parties, court action, all these kinds are very, very important. Any of the party to the agreement can submit in writing to the tribunal within 15 days of the knowledge or original agreement. That is very, very, very important. Otherwise, problem will come. Arbitral award. Just now I said decision of the tribunal, temporary, interlocutory, partial, monetary, non-monetary, all these kinds of things will come under arbitral awards. Types of awards. Just now I said domestic, international commercial awards, foreign awards. Domestic, international, domestic purely India, in the international one of the party from outside India, foreign both the parties are outside India. These are the distinctions between types of awards. Domestic award, just now I said both the parties are India, given by the tribunal, in India. Foreign award held in a foreign country, foreign arbitrator, foreign laws, foreign national. Parties must have commercial relationship enforced in India. That is very, very important. You may get award from foreign country, but that foreign country award must be respectable by our Indian laws, public policy of the India. Then only you can execute that foreign award in India. That is very, very important. Otherwise, you cannot execute that award. That is the reason before going to that kind of level, you must take legal opinion from our Indian lawyer, then go for foreign award. Otherwise, no. Next, just now is the enforcement of award. Yes, finally, no application for setting as section 34 for up to 120 days. This is very important. Up to 120 days, there is no setting as, there is no application for setting. Enforcement will be done as per the CPC, as if it were a decree of the court. In the Arbitration Conciliation Act 1996, there is no any special laws for execution of the award. Again, after getting the award, they must come to local court, and you have to follow jurisdiction. Then you have to file EP petition, execution petition in the concerned regular court for enforcement of the award. Coming to enforcement of foreign awards, New York Convention, Geneva Convention. As on today, in the case of enforcement of foreign awards, we have two kinds. One is New York Convention, another one is Geneva Convention. Award is valid in accordance with the agreement, no undue influence, meets morality and natural justice. Again, I am saying, in the case of foreign awards, meets morality and natural justice and respectable our Indian laws and our public policy of the country, then only foreign awards will be executed in India. Otherwise, no. What is foreign award is equal to court decree of the Indian courts. Foreign award is equal to decree of the court as per New York Convention section 49. New York Convention section 49 says whatever the foreign awards are there under New York Convention, that is equals to Indian decree of the district court. Geneva Convention 1955 section. Applicable awards. Tribunal acted out of its jurisdiction. In this ground, you can go to appeal. Tribunal acted out of its jurisdiction. When it is possible, whatever the jurisdiction is there, both the parties must write in the agreement. Arbitrator cannot go beyond the agreement. That is which are there in the agreement. That is called as jurisdiction. If you go beyond the agreement, beyond the jurisdiction, other party, victim party may go for appeal. Serious irregularities in the process. What are the serious irregularities? You can find out. Taking money from other party, getting the false evidence from the other party, wrong document from the other party, these kind of things. Concerned with, against law and public policy. Concerned with the interim measures. Section 50, New York Convention. Section 59, Geneva Convention. These two are deemed appealable awards. Thank you very much for giving me opportunity. Again, we have to discuss so many things. We require one more lecture to complete other things. Thank you, sir.
Thank you very much, sir. Thanks for your valuable information.
Thank you.
Thank you, sir.
Thank you
sir.
so much. It was a very insightful and elaborate coverage of the topic, alternative dispute resolution. I hope all the participants have benefited from this presentation of Professor N. Venkateswarlu. Thank you so much, sir. Now, the session is open for questions from the participants.
Yes, sir, there are a few questions. Can I read it out, sir?
You can ask.
Hello. Yes.
Excuse me, sir.
Yes. You can do one thing. We can do one thing. You can put your questions, your queries in the chat box so that we can ask directly to sir and sir can reply. So that will be better for us.
Sir, otherwise you take my WhatsApp number. Whatever
Okay.
doubts are there, even after this class also, I can, because I have exam, I will be the chief student for exam. I have to
Okay.
go.
Okay.
10 minutes I will give, sir. Please proceed.
Yes. For 10 minutes, sir will give. We can discuss with sir, and if you have any doubt, thereafter we will share the WhatsApp number of sir, and you can contact him directly. No problem. Sir, there is a question, sir. Is there, if there is a dispute in online e-commerce contract, ODR method should be taken into consideration or not?
Yes, you can take ODR mechanisms. In India, nearly 10 service providers are there. You can depend on them. Otherwise, if in your agreement, if both the parties are ready, you can appoint any arbitrator, ask him to deal through online. That is video conferencing. That is also valid as per Supreme Court judgment.
Actually, there is another question, sir, regarding mutual arbitration. Is there any? The student actually wants to elaborate a little bit regarding mutual arbitration.
Mutual arbitration, it is there. We are calling it as negotiation only. You can see both the parties can sit together and they can discuss each other. They may come for mutual understanding. After coming mutual understanding, they can go and file a pre-litigation case in the Legal Services Authority. They will give award without any money expenditure and everything. This is very important question for poor people also. See, whenever a dispute is there, they can sit somewhere, mutually they come for conclusion. Same that conclusion only, after getting conclusion, they may approach Legal Services Authority on the name of pre-litigation case, not post-litigation, pre-litigation case. Please, PLC, pre-litigation case. Specifically, you mention in the Legal Services Authority, based on your understanding, based on your outcome, they will give award. After getting award, there is no appealable also. That is 100% valid. Next.
Yes, sir. There is another question, sir. Two arbitrators go through the case files and call up the litigants, asking if they are interested to go through the arbitration process instead of the conventional method of court trials.
I am not following.
Yes. So his question is, two arbitrators go through the case files and call up the litigants, asking if they are interested to go through the arbitration process.
Very good. Suppose already one case is pending before regular court. Okay. Years together, matter is gone. Days are coming. Parties become parties wants to settle the matter outside the regular court. Then one of the party can request the regular judge to transfer that matter to legal services authority for settlement of dispute. You can settle the matter outside the court settlement, outside the court. Even judge also transfer that original file to legal services authority for settlement of the case. After getting one conclusion, again we will send back to the regular judge for settling the matter as per the understanding MOU given by the parties in the legal services authority.
Yes, sir. Yes.
Yeah. Sir, I'm the colleague. I'm from Department of Law, Usmania University. I have a question to ask to the resource person, sir, if permitted.
Most welcome, sir.
Yeah, please, can I proceed?
Yes, you can proceed, sir.
Very good morning to all the participants and the organizers. My question is very direct to the speaker because he has elaborated all the pros and cons of ADR mechanism. Now, because he was speaking about how to resolve the dispute in a simple and a very quick manner. My question is very direct. What would be the emerging area is artificial intelligence? How artificial intelligence is going to help in resolving the dispute in the near future? I request the resource person to comment on this.
Very good question, very important and relevant question. See, nowadays, after information technology, we are seeing so many developments in the court of law. Day by day, even artificial intelligence and already chat GPT and so many things are happening. Recently, one of the Supreme Court advocates, he adopted chat GPT for arguments. In coming days, in the place of arbitrator, you can find machine learning, you can find technical person who properly processing, otherwise programming to the particular person, artificial intelligence person, automatically he will give the judgment in coming days. That is question of human rights, question of profession, question of so many things will come into the picture in future. We have to wait for some time.
Then it will be a problem for the profession now, sir.
Yes, already section 89. Since section 89 onwards, our professionals are feeling bad day by day, till today. So many developments are happening. In future, in the place of advocate, mission advocate will come into the place to solve the problem.
Then what about the, professionals, sir? Then it will be a problem now, sir.
That is question of human rights. We have to discuss in some other way.
It will be a dispute, sir. It will be one of the dispute in future.
Yes, we have to update. Otherwise, we have to update. Next, Ramprasad. Professor Ramprasad.
Sir, there is another question, sir. If either of the parties is not satisfied with the judgment appointed ADR in the court annexed arbitration, can that party approach High Court?
Yes, exactly. In the case of court annexed, this is very important. After sending the regular file, after sending the original file to Legal Services Authority, they will counsel the parties for settlement. If counseling is failed, again he will send back to the regular court. In that remarks, Legal Service Authority Chairman says counseling is failed. Once counseling is failed, again matter will go in the regular court. In the regular court, whatever the judgments comes, victim party may go to the court.
Sir, in addition to the previous question, is there any time limit for appealing?
Yes, as per limitation act only. There is no any kind of rules for this method. Only limitation act will only applicable. Next. Thank you, organizers, for giving me opportunity. In future, we require one more lecture on online disputes resolution. If possible, you can organize. I will take online disputes.
Thank you very much,
Sir,
sir.
thank you, sir. Thank you so much, sir. Thank you so much.
Thanks a lot, sir. Wonderful presentation, sir. Presentation.
Formally, I would like to offer the vote of thanks. I would request Spinita Madam to offer the vote of thanks formally. Just within 5 minutes, they will be offering, and thereafter we can close the first section.
Thank you, Gogoi sir. The great afternoon to all the honorable dignitaries and distinguished guests and my dear participants. On behalf of PG Department of Law, Barampur University, I feel immense pleasure to take this opportunity to propose vote of thanks to all the esteemed guests and all the participants of this inaugural and the technical section of the workshop and the altar of on. We are very much thankful to our Honorable Vice Chancellor, Professor Gitanjali Das Madam, for constant encouraging us and providing opportunity to organize such events. Thank you so much, Madam, in absentia. We profusely thank Professor Sushant Kumar Baral Sir, the Chairman of PG Council, for his support and encouragement. I would like to thank you, sir, for your valuable words to the online gathering and gracing this event. I take this opportunity to special thank to our today's resource person of past session, Professor N. Venkateswaralu sir, the head and principal of Department of Law, Osmania University, Hyderabad, for his relevant address on law relating to alternative dispute resolution and mediation in India. I am sure participants immensely benefited from your informative lecture. Sir has rightly delayed is justice denied. As in today's court are overburdened with a huge number of cases to dispose of. The Adr system will definitely help to lessen those burden systems on court. And about the parties, with that idea, they can avoid those cumbersome and lengthy and costly court processes. Thank you, sir, imparting such a knowledgeable session. Our special thank goes to the resource person of second session, Ms. Krishnan Arjun Badade, Assistant Professor, MM Shankar Rao Chavan Law College, Pune, for enlightening the upcoming section. We thank Mr. Chittaranjan Gogoi sir, the Assistant Professor and the Coordinator of the Department of Law, Barampur University, for organizing such a workshop for the benefit of the participants. Thank you, sir. Our next thank goes to Luptaratna Patra sir, the faculty member, for encouraging and welcoming the gathering. Thank you, sir. Our deep sense of appreciation and thanks goes to all the esteemed faculty members of different law colleges and student participants for active participation with great enthusiasm and made this workshop successful. Once again, I thank you all for being with us on this virtual mode of this workshop. Thank you. I request Dr. Lupta sir and Gogoi sir to conclude this session.
Yes, yes.
Concluded. Okay.
We can resume the second session from 2:30. 2:30, it is. We can resume the second session. The participants are requested to join at 2:30. Thank you very much.
Sir, see that it is started on time, because first session was going late. Please see that it is started on time.
Yes, 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 yes.
Good afternoon, sir. Sorry to interrupt. This is Shweta here. Do we follow the same link for the second session?
Yes, yes, yes. The same link. We'll resume at 2:30.
All right.
All right.
Thank you so much. It was a wonderful session. Yeah. Thank you.
Thank you. Thank you very much. Thank you very much for joining.